Hello there, and many thanks for joining us on the program. I am Imonia Marere. In the wake of the litigations and legal challenges that were mounted over the 2023 general elections at different levels, but in particular against the outcome of the presidential election, many informed and uninformed, lettered and unlettered, experts and laymen have been having a field day insisting that their understanding or lack of it should be the position of the law and the Constitution. In the interpretation of the laws and the dispensation of justice by the election petition courts. Some have gone as far as mounting pressure on judges through media campaigns, some of which could pass for outright blackmail and incitement. Disappointed partisans have unleashed their frustrations on the judiciary and have been unsparing in the abusive and costive manner they have been thumping the judgments and judges of the various election courts, especially when they do not go in their favor. They have gone as far as branding the judges and justices in all sorts of negative appellations. As observed by the Chief Justice of Nigeria, Justice Olukayode Ariwola, and I quote him, "Vitriolic attacks are regularly heaped on the judiciary," end of quote. It was perhaps on account of this untoward situation that the Chief Justice, a few weeks back, admonished that public opinion cannot override or supersede the Constitution of the country, which judges apply in deciding each case. In other words, public opinion cannot and should not take precedence over the law in the adjudication of cases and in the delivery of justice on any matter. This admonition has not stopped nor tempered the way those who see no good in the judiciary. Yet, some legal minds insist that justice in any clime, including Nigeria, is according to law and not according to public opinion. Law and justice, they say, are devoid of sentiments. The question, therefore, is whether emotions have a place in the administration of justice. Should public opinion be allowed to play a role in judicial proceedings? Should judges gauge the mood, the public mood, in reaching their decisions and delivery judgments in disregard of evidence and the provisions of the law? To what extent would that be, or how far can that go if this is allowed? These are the issues that we will be looking at on the program today: people, politics, and power. We shall go on a short break, and when we return, we will be meeting our guest analysts.
The Nigeria of our dream, the Nigeria we need, is the united, indissoluble, and cohesive Nigeria which guarantees equity, fairness, justice, and prosperity for its citizens. That is our focus on people, politics, and power. It is fresh, insightful, impactful. It's a must-watch. People, politics, and power on AIT.
All right, thank you so much for staying with us. Well, I'm joined in the studio here, right here in Abuja, by Mr. Jerry Edemeka, who is a seasoned lawyer. Thank you so much for joining us, sir.
Thank you so much, and thank you, viewers.
Welcome.
Yes.
Joining us online from Lagos is Professor Sylvester Ojo Ahaine. Professor Ahaine is a political scientist. Thank you so much, Prof, for joining us. Prof, I
Thank
hope you
you.
can hear us.
Yes, right. Very well. I'm hearing you.
Okay. We're also expecting to join us another professor, but this time a professor of mass communication at the Bayes University here in the nation's capital, Abuja, Professor Abiodun Adeniyi. He will be joining us very shortly. Right. So, Mr. Demeke, let's begin with you here in the studio. I mean, you've been in Nigeria for all this period since after the elections, and there have been a lot happening, particularly in and out of the social media and in the media generally about what the public expectation should be of the judicial administration of justice system as far as elections are concerned. Now, first, let's have your take on what you think of all that has happened with the judiciary since then.
Really is a very delicate situation. It's a difficult thing to place just to make a definition of what has happened. The society, the public expectation has been on the rooftop, and sometimes one really has to take a look at the judiciary. And everywhere you go, people say, oh, the judiciary is on trial. The judiciary is on trial. So it looked like after the politicians have done their own, they have contested elections, and then all the allegations of riggings and non-riggings, at the end of the day, it looks like the cynosure, the focus, the center of the storm now shift to the judiciary. And I must quickly add, unfortunately, the judiciary is that one arm of government that doesn't really get into the marketplace. It doesn't get into the social space to defend itself. So that's just the other side of it. But again, it's important also to say that if the nation has to grow, if the sentiments that we are having, if we have to curtail it, we have to take a look at the judiciary. And taking a look at the judiciary, there's a lot to it. How do we appoint our judges? Do we have to go even into the brass tacks? We have to go to the basics. So the appointment process, is it right? Do we have the square pegs in square holes? Do we have the right persons at the right position? So sometimes, because if you listen to the sentiments, in the public domain, a lot of people are saying, oh, is a trade by barter, there's been injustice, there's been corruption. It is because the public, from what it appears, are not trusting the people we have sitting in the helms of affairs, in the court, not just the Supreme Court, not just the Court of Appeal. Generally, the people in this arm of government, they are held in some kind of suspect. People are not trusting the men that we have in authority in these places. Something must be wrong somewhere. I feel that as much as we don't need to bend and succumb to the sentiments and the public space trial and media trial and social media, we also have to point the searchlight and say, have we gotten it right in this arm of government? Are the right persons at the right places? Are they doing the right thing? So that question is quite loaded.
Now, how much of the judicial system or how much of the legal system does the ordinary man understand to be able to begin to inquire into and indeed begin to criticize what is done right and what is not done right by the judiciary? From a lawyer's point of view, how much knowledge does the ordinary person, does the person in the public know of the judicial system?
And unfortunately, it doesn't appear to me that the average person on the street, the ordinary person, understands much about the judicial process and the judiciary itself. And a lot of times I used to find myself trying to explain that even the judiciary happens to be probably the only arm of government that has an inbuilt censorship within its structure. So you have like the National Judicial Council, which looks into the activities of judges, can censor a judge, and if a judge is not living up to expectation, a member of the public can write a petition against a judge, submit it to the National Judicial Council. The judge will be subjected to trial. So a cleansing system is actually in place. But how much of that is applied? But the truth of the matter is that members of the public don't really know so much about the workings of the judiciary. They don't, because that is an arm of government that is shielded. You don't have members of the judiciary coming on the television to speak and to defend themselves. You don't have them in the social media space and all that and all that. So at the end of the day, it is the most, would I say, the most, should I say secretive, the most unknown, the most that is not publicized, their activities. So that has not also helped matters. So that is one aspect. But crucial, very crucial, is the fact that the public is prying into who sits in the place of judgment. Who sits in the place of judgment? Is it a person that comes with clean hands to deliver judgment, with conscience, with what it is supposed to be? These are questions the public, members of the public are asking. And I think they have a right to ask.
In other words, you are saying that members of the public are laymen and women as far as the law is concerned, as far as the judicial processes and proceedings are concerned. I'll come back to that very shortly. But let me at this point acknowledge that Professor Abiodun Adeniyi, who is a professor of mass communications at Bayes University here in the nation's capital, has joined us. Professor Adeniyi, thank you so much.
My pleasure. Thanks for having me on.
Well, we also have online Professor Sylvester Odion Ahaine. Of course, we introduced him earlier, but let me come to you now, Professor Ahaine. I'm sure that you have heard the very first intervention of Mr. Jerry Edemeka. As far as the legal system is concerned, the judicial process and proceedings in Nigeria, and how much the public have tried to either influence, intimidate, or harass judicial officers in the recent past. The big question is, does public opinion have a place in judicial proceedings? From a political scientist's point of view, what is your take?
I think the point to make is that as an aftermath of the last general election, there has been quite opinion in the public space in terms of what the judiciary should be doing, what should be, its rating in terms of performance vis-a-vis public expectation. That is there. But I think that when you look at the judiciary as an arm of government, it is separate from the legislature, it is separate from the executive. And so it has its own role spelled out for it. And the judiciary operates within the ground norm, the constitution of the state, of the society. And so it cannot operate aside of that. But in terms of how public opinion is brought to bear on the decision of the judiciary, I think what we should be looking at is what we in political science will look at as an input, input and output, process, in the sense that opinions are there. Opinions cannot alter the laws of the land immediately. You have to go through amendment, those views have to be collated and said, and look, people will say, look, we need to change, the constitution, we need to change the laws and all of that. So it has to go through procedure. So I think that public opinion can contribute, to the science of law itself, to jurisprudence. That is where it comes in. But you cannot expect public opinion to alter, the process of the judiciary when it is being conducted within the context of the extant laws of the land. I think that is a point that we must get clear, in all this.
All right, let me bring in Professor Abiodun Adeni at this point. Right, as a mass communicator, I mean, this is one area where you are an expert in terms of how much has been done in the recent past using media outlets, whether traditional media, social media, whatever form of media that has been used in recent past to try to weigh in on what the judiciary is doing.
Oh yeah, very interesting subject really, because it has become all the more important, especially in the wake of the general elections, where we have had deep-seated public opinion, some of them much more vociferous than the other, trying to shape the outcome of the election, through the judicial mail, in a situation where we understand that the judicial mail can often be procedural, working through the instrumentality of specifications in the law. But there's something that I think we should ordinarily understand, that there's a marked difference. I mean, this thing has been proven in history, a marked difference between social justice and moral justice, between social justice, moral justice, and legal justice, between justice and judgment, The one that we should be familiar with is the one that expects, of course, which is stipulated in the system, that at the end of the day, there should be all kinds of justices, but the one that is supreme, there could be all kinds of justices, but the one that is supreme is actually the legal justice, supposedly, or which is supposed to be administered by judicial officers. And there's a reason why we have systems, where we have structures and institutions in a social system. It's just about order. Sometimes you expect this to be commonsensical, but again, you are at pain when you see the trifle of public opinion obfuscating this understanding. And of course, you can probably not blame the system or the society or those who are supposedly opinionating, because it depends on their character strength. They often feel that their opinion should override. And when you see a conflation of those strong charactered opinion coming together, you can expect that, to weigh into, you can expect it to have a heavier weight, on social, political, and economic discourses. We're in a period of our life where the venue for the expression of public opinion is expanding, and it is continuing. Channels have been pluralized, and we are having a multiplication of individuals. It doesn't matter their level of understanding, profiling their opinion. And some of them can be strong charactered to the extent that by the time they raise their voice, the decibel becomes even higher than the one who is supposedly informed. So there can be confusion in the matrix if you are not careful. That's why the place of structures, the place of institutions are very, very important. But at the same time, we cannot undermine the place of public opinion. I think Professor alluded to it, because public opinion is a place, where you see contestation of ideas, and of course, by the time you put them together, sieve them, separate the wheat from the chaff, you can begin to see something that is actionable, through which growth and development can come in. Society can now make progress. But in our case, we have witnessed it, and I'm happy overall we have seen what looks like peace. You may say it's an uneasy calm, but overall there has been peace. There has been a conclusion. There's nothing extraordinary to what we have seen, and that's why judicial officers have often reminded us that public opinion is different that the law is different from public opinion. The law is a nurse, it walks through the empirical point, the scientific point of the law, which has nothing to do with morality, has nothing to do with emotions and sentiments. No matter what emotions and sentiments are, what we think they are, the law is there. But the problem now is, I think what agitators are concerned about, that there's a distance sometimes between judicial interpretations and expectations, and reasonable, logical expectation. So how do we bring about that compromise? That's what I think we need to probably begin to think about, which could happen as well through the instrumentality of other arms of government, particularly the legislature.
All right. Now, Professor Haine, flowing from what Professor Adeni has just said, do you think, for instance, that what we are going through at the moment is a process or part of our democratic development, the development of our various institutions in Nigeria? Is there a precedence in history that we can look up to say, look, oh, country XYZ went through this process at one time or the other to get to where they are now?
Well, I'm not sure I got you very well because there was noise at the background here. But however, I think that the process we are going through, democracy itself is a process. And that is why we talk about democratization. So democracy is an unfinished business, as far as it is concerned, as a process, it's an unfinished business. And so we have our lows and we also have our highs in terms of how we advance in the democratic process in Nigeria. I think part of the thing is that the new media was brought to bear in the last general elections. So views were multiple and there were contestations here and there. And people, of course, had perceptions about the outcome of the electoral process. But it did turn out, that way. Some of us have different perspective and perception about the electoral process and the power dynamics in Nigeria. At the end of the day, whether one school is right or the other is wrong, that is not the issue. All matters went to the judiciary. And I think that the judiciary will continue to adjudicate or mediate the democratic process in Nigeria. And to the extent that it brings about improvement in the process. And I think that is the beauty of the democratic process. And that is also the beauty when you allow the rule of law, in the motion of society. When you allow the rule of law in the motion of society.
All right, let me come back to you here, Mr. Jerry Edemeka. Let me return to that question that I left hanging initially, which is about the role that lawyers should play in the education of the public to get laymen to maybe understand the legal processes and procedures much better than they do at the moment, and in the process, hopefully make more informed commentary on judicial or legal matters, as Professor Adeniyi will want to put it. Are lawyers doing enough in that regard? Have you, the MBA and individual lawyers, doing enough to conscientize the public, the ordinary men and women like us who do not understand the legal provisions and legal processes, to enable them understand better? Because even then, you also see learned men and women of the sake of, who make certain comments, and such comments will keep you wondering whether actually these are lawyers or not.
Yeah, you see, like has been said, the law is said to be an art. There's no very strict, indivisible interpretation of the law. That's why if you have a number of lawyers on this platform, you are likely to get differing and varying interpretations of the law. The law is not such that can be subjected to that kind of empirical, scientific demonstration and interpretation, as the Prof was saying, that everybody will reach one irreducible conclusion that this is the answer. The law is not like that. You don't have one answer because it is a flexible entity. So that's what it is. So I think I don't think there's anything to point blame or to feel that maybe lawyers are not doing enough, because the subject of the law is fluid in nature. So that's why you have what you have. But I think like the Prof was saying, people will continue to have public opinion. People will continue to be agitated all over the world, from the UK to America. Once it gets to election time, you'll find agitated public opinion, the informed, the uninformed, they have contributions to make. Public opinion, the space, the social media space is so vibrant, so busy. People are expressing opinions. Some are informed, some are uninformed. But the basic thing is, I believe that, like the Prof was saying, that we have the concept of morality, we have the concept of the law. So public opinion, most times, they try to shape how we reason and try to present even to the judiciary that, oh, this is a moral question. We have a moral question. How do you look away from a moral question? But again, the judiciary does not subject itself to the content of morality. Morality is beautiful, is nice. It should ordinarily, everybody should look at issues from the point of view of morality. But unfortunately, law is not like that. It doesn't really dwell on morality. Law looks at the legality. It's a regime of legalism. What are the precedents? What has the law specified? What has the law said? When this case was decided in so year, what were the ramifications? What did they look at? So law is not like that. But one thing also must not escape our scrutiny. In all this public outcry, public sentiments, emotions spilling all over, there's one thing the public expect. The public expect that when we have an issue of justice, when a certain kind of justice is being expected, whether it is moral justice, whether it is legal justice, the public will not expect that the judiciary should shy away from making pronouncements on the law on the altar of what we call technicalities. You see, technicality also defeats the essence of the law. It defeats the essence of justice. So when you see laws being, decisions and judgments being interpreted and being delivered on the altar of technicality, that means the judicial process, the prism at which the judges use, was not to look at the justice of the case, was not to look at the content of the case, was not to look at the morality of the case. I said morality doesn't necessarily kind of shape the law. But when they say, oh, because it is technical, because of technicality dismisses the essence of justice. And a lot of times it looks to me, especially when it comes to election adjudication.
Is the law itself not technical in itself? I mean, ab initio, it's law, not technical.
The Supreme Court has said it time and again. The Supreme Court has said that we should not allow technicality in judgment to defeat the essence of judgment. That is judgment, a fair judgment. Because when you...
But I understand the Supreme Court saying that, but yes. I'm asking, as a lawyer,
yes.
Is law not technical in itself?
Every profession is technical, but in the application of the law, it should not be, when we say technicality in law, we mean that you bring an issue before the court, and maybe the prof has an issue, and he said, this is the issue I want us to look at. And you said, no, even though this issue has merit, but we cannot look at it because probably the prof did not come on time. He just came 2 days late. Or the prof said, oh, I just saw somebody who was manipulating.
There are processes and procedures for which is where the technicality in law comes in.
Let me tell you that
can you throw away?
Let me tell you the irony of technicality. It's like the prof comes in and says, as I left the studio, I saw somebody fidgeting with my car key, and he was sitting down and about to drive it off without my permission. And we know what the law says about stealing. The law says that you have taken something that is not yours without permission, without the consent of the owner, with the intent of depriving the owner of the use of that thing. You have all the elements present. But you take it before the judge. He said, oh, that the prof ought to have filed this thing 2 hours before the time it was filed. So they have not looked at the elements of the offense.
The substance.
They have not looked at the substance. They have not looked at the justice. But they say, oh, because the prop did not come on time, a whole...
But you know that only happens, as it were, with election adjudication. It's very rare to have civil or even other criminal cases have such, say, procedures and time bars and all of that. But I will come back to that. Yes, I'm very sure. I'm sure. I'm sure of that. But I'm
familiar more with election cases.
Yes, you know, yes. But the point I want you to focus on is the media. The media is very critical to the expression of opinions and views by individuals, groups, organizations, and what have you. And the media has been very critical in this regard in trying to disseminate information and public opinion, opinion of individuals on issues as far as elections and the legal system have been concerned. Are you concerned, for instance, that the kind of role that the media, traditional and non-traditional, have played over time, and particularly during electionary periods in Nigeria?
Okay. I think we should make a quick differentiation, Mark. Brilliant question, no doubt. But let's make a quick differentiation between the media that we're talking about. We're in the times where we can effectively differentiate between the hard and the soft media. I would say the hard media are the ones that we know, the traditional legacy media, legitimate media, open space media. They're the ones that are supposedly more credible. Supposedly, mark my word. And of course, we have the soft media, the social media. And the question is if they have been helping to disseminate. But we're in a season where people don't wait for people to help them to disseminate information or to express their opinion, where people are able to express their opinion directly only because they have the smartphone on their hands. You know,
the soft media, as you call it.
The soft media,
yes.
Through different platforms. You know,
and in doing it with a
be very
responsible
effective.
manner.
Yes. And they can be very effective in doing it. Everybody will know them. A simple, remarkable tweet, for instance, can capture everybody's imagination, and attention will be drawn to it, from it going viral and all kinds of things. That's the age we are in. So people are not able to help themselves, rightly or wrongly, correctly or incorrectly. But most of the time, of course, it's also convenient for us to classify that section of the media as largely replete, with mischief, misrepresentation. And of course, you can actually also say there are more psychopaths on there than you have in the regular, hard, legitimate media. Without necessarily saying that it is of no use. They have their own uses, and that's why people are talking about some level of control, some level of moderation. And that's the reason why we also have systems and structures in a social system. Because no system, no society moves mainly on the basis of the trifle of public opinion. Public opinion can be fickle, can be feeble, it can be difficult to put together, difficult to synchronize such that it will lead to action and policy direction. And that's why we need, government, we need leaders. The elites have come, to put together some public opinion, shape it in such a way that it can fit into action, for implementation and for development. That's the philosophy behind, the creation of institutions in every social system. And our own cannot necessarily be different. Even the law has also, the structure of the law, the structure of the legal institution. It's also so smart to say that let's have court of first instance, court of appeal, and the Supreme Court. And I'm happy when lawyers talk about the Supreme Court not merely being a court of, a hard court like that, looking at only the substance of the case.
It's a court of policy.
Court of public policy. You can see how systems are shaped, and that's why I said earlier, the good thing about our own system, like it has happened the last time, is that, yes, there might have been some kind of ululation, some kind of noise, some kind of bedlam. At the end of the day, we have gotten to some kind of peaceful closure to the end of it all, through the judgment that we had yesterday. How we proceed is in the bag, but of course, there's still another tomorrow, as the case could be.
All right, let's bring in Professor Ojoaine now. Okay, we hope that he's able to rejoin us very shortly from that end in Lagos where he is. Hopefully, the network will allow him to rejoin us to make his contributions to the program. But for now, let's take a very short break and we'll return in a moment.
The Nigeria we need is the united, indissoluble, and cohesive Nigeria, which guarantees equity, fairness, justice, and prosperity for its citizens. That is our focus on people, politics, and power. It is fresh, insightful, impactful. It's a must-watch. People, politics, and power on AIT.
Thank you so much for staying with us. Professor Diohane is making a very serious effort to rejoin us. But here in the studio, we have Professor Abiodun Adeniyi, who is a mass communicator, Professor of Mass Communication at Base University here in the nation's capital, and Mr. Jerry Edemeka, who is an Abuja-based lawyer. Mr. Edemeka, thank you so much for finding your time. Before I went to Prof, I was talking about election processes vis-a-vis other regular civil or even criminal matters. You are in the profession. You know very well that when they talk of technicalities, these are part of the law that is put in place, for instance, to say, look, when after election has been declared, for instance, you have 21 days within which to file your brief, your challenge of existing. And from the time of filing that brief or from the time of declaration of results, you have 180 days for this election petition to be concluded. And if you decide to go on appeal, another 60 days at the Court of Appeal. Those are part of the law as accepted by all who went in. Every game has its rules. And those are the things that have been accepted. And so when judges or justices at every level interpret such rules and such legal statutes, they do not necessarily constitute technicalities. They are part of the law.
They are part of the law, but you see, like the Prof said the last time, it's quite unfortunate. It's a bit not very comfortable when, if you go back to the illustration that I was trying to make the other time, which is an illustration in criminal jurisprudence, in criminal law, you find that in criminal law, for instance, the law has a specific definition for stealing. I go back to that. The law says for it to be stealing, that you must have taken this object without the consent of the owner, and that the intent of taking this object would have been to permanently deprive the owner of the use of that object. And here you have a situation, and you have seen somebody who has taken your object with the intent of depriving you of the use of that object. He had not your consent, didn't take your consent. So all the elements of the criminal offense are met in that situation. And you take it before a court. And this is a man who took my object without my permission. And they look at it and they say, look, yes, we have seen all the elements present. We know that this is your own, that this person did not have your consent. But unfortunately, the law says that you are supposed to file such a process 24 hours or 48 hours before the hearing. But you file it less than 48 hours before the hearing. So you now see that the man who took your thing, who deprived you or who attempted to deprive you or had indeed deprived you of the use of this object, walks away triumphantly with your thing because it was not filed 48 hours before the time. That is the kind of technicality I'm talking about.
But you know that you as the individual, the aggrieved individual, also has a remedy in law. You can, from the court of first instance, go to Court of Appeal.
That's what
and from there to
Yeah,
another level.
I'm talking about when you get now, I'm talking about you get to the apex court, in this case, the Supreme Court. And it sometimes makes the public to feel a sense of loss, in quote, a sense of loss. The public feels it so terribly when you feel that, or when you know that certain elements had been met, but that it was technical justice. It is not always beautiful when you see somebody walking away triumphant only on technical grounds.
So
that is the only issue that I feel we need to redress.
That
or
brings us to
readdress.
the issue that you raised earlier, which is that of public expectations and the law. Which should take precedence over the other?
I think the law should take precedence. Otherwise, there will be crisis, because public expectation sometimes, I want to use that word, may not necessarily be, it may not be scientific, It can just largely be a trifle. And it can be about emotions, about sentiments. It's like something that can be likened to the mob. You're talking about the mob, and you know how dangerous the mob can be. If you remember what happened to Cinna the poet in the old Roman Empire, the mob can be fickle-minded, hardly reasonable, because they are acting simply based on, the safety that could be in numbers. And when that happens, of course, there's no organization, there's no order. Sometimes within the mob, you will find credible voices, but most of the time you'll find discreditable voices that are hardly informed, and that is also definitely disadvantageous to any growth and development plan, any progress that the society can make. So yes, public opinion can sometimes be credible, but you need it to be harmonized, through structures, through institutions. And of course, that's why we have the law and its regular arms, or the regular features that are associated with it. I'm talking about the adjudication process. These things didn't just come overnight. Even in dictatorships, you still have that situation where the process of law is privileged. Structures are still there to give processes or decision semblances of credibility, so that people can also be at peace. There will be some level of social sanity. It has grown over the years, and of course, the world is also still growing, still evolving. But what we need to do is we cannot be different. All we can do is also perfect our own system, make it a little more creative and ingenious. Let's be realistic about the facts that emerge from this institution, which I think the barrister has been talking about, that, the key improvement we can make is just to make sure that, when judgments are made, people don't see it only from the prism of technicality, because technicality can be largely irritating, largely painful, where everything can become, it's largely a matter of subjectivity from the point of view of those who are presiding, and any argument can be rigged up as bordering on technical hitch or technical failure. Which means that something hidden is actually lying there. You probably are trying to avoid the issue and make a non-issue to be the plank around which you will place my judgment. Ordinarily you see it as unfair, and you just see it as something that should be unacceptable. It's a development that we can actually examine, or something we can move away from. But again, this rests within the courts, of the judiciary, as the case could be. But the gratifying thing again is that they are very much aware of these things. I mean, they know. I've had very senior members of the bar talking about it all the time, and that, even in the Senate, there was a time it was featured. So if there's knowledge of it, it means that we understand the dynamics, all the dimensions of it, and we know that there's something that is a wrong that we can probably right at some point, as we go forward. Yeah.
So, Barrister, should judges make some effort engaging public pulse, the public mood in delivering judgments, particularly judgments that are bordering on electoral disputes, for instance? Would that in any way advance electoral jurisprudence?
I don't think it will advance electoral jurisprudence. To start with, by the nature of the duty of judges. They are kind of insulated. They are cut off from interference with members of the society. The moment you are appointed as a judge, you are not expected to be seen much in the public space. You are not a socialite. You cannot socialize. So because of that, it's like they are so isolated. So sometimes you may wonder whether they are even aware of most of these agitations on the social space. So, but the truth is that the moment the law becomes captive, becomes a subject that has to be regulated or moderated by what we have in the public space, in social media, the hard and the soft media, as the Prof was saying, as soon as you do that, the law has taken a dive for the worse. The law must continue to be the law based on precedents, based on the judgment, based on what is the merit of the case. I emphasize that, merit of the case. Not necessarily based on technicality, based on merit of the case, not based on public sentiments and opinion, but the merit of the case. Because judges are appointed to look at cases on the merit. And once there's a departure from this platform of merit, there will be an outcry. You have all the hullabaloo, the social space will be agitated, and all that and all that. So it is important for judges to continue to mind their business, to continue to look at the letters of the law, to continue to give jurisprudential interpretation according to what is right, according to what the merit is, and not according to public opinion.
How do we insulate judges and justices of the higher courts from the society? Modern time society where the social media is in your hands.
Yes.
If you own an Android phone or any other type of phone, you are exposed to it. Now, the judges may not, may insulate themselves from, say, social gatherings and all the other social activities, but can they necessarily be insulated from the social media, where most of this, what we have been talking about, actually takes place?
On this aspect, the judges are somewhat disadvantaged in the sense that they cannot be isolated, they cannot be separated from the society. The society now is a society that is being almost shaped, for the most part, by opinions in the social space, in the media. But judges, who are also part of the society, they also hold the Android phone, they see what is going on, even though they are separated from interaction and interfacing with the normal day-to-day going on with the society, but they are also reading, they are seeing what is going on. But again, they cannot speak out. They are not expected to reply. So if you say a judge is corrupt, the judge is not expected to reply because he's not trained by the nature of his calling, is not to reply. So that's why I feel they are disadvantaged because they can't speak to defend themselves. If you speak about the National Assembly, the next day in the parliament, they are going to get back at you. They will talk back. If you do that against the executive, they will talk. They may even arrest you. But when you talk against the judge, he has no means of coming back to reshape the opinion and to defend himself and all that. That's where they are disadvantaged.
Okay, Prof, as we round off our discussion, what do you think would happen if and when this kind of emotive and sentimental outburst that we have seen in recent times against the judiciary and against judicial officers continue?
Okay, there's something that we need to understand, that in communication, in discourse, in messaging, there's a lifetime to every content that you disseminate. You know, and in this case, where we have a plurality of opinion, some of them becoming very emotional, very sentimental as well, there's a timeline to it, you know, consciously or unconsciously. And that's why you see that if you look at everything that has happened in the last 6-7 months, they will come, they will blow over, it will look as if the world is going to end. But before, no sooner had that thing risen, you know, then you now see it will start thawing. You know, there's a timeline to everything. Now, there's a closure from the Supreme Court judgment yesterday, very soon, whether you like it or not, consciously or unconsciously again, we're going to move to something else. That's how things work. It's so natural, except one or two persons unit in the whole now decide to elongate it. But in elongating it, you will see that even your strength to continue with it is gradually becoming weakened because all those around you, are beginning to look elsewhere. Then it will tell on you at some point. That's the nature of it. So it's not something to worry about. It's the way of communication and messaging. And this has been proven over the years. And if you want me to give some other evidence, I can.
Thank you so much, okay. Professor Abiodun Adeniyi, mass communications expert, professor of mass communication at Bayes University here in the nation's capital, Abuja. Thank you so much for your time to join us. Mr. Jerry Edemeka is an Abuja-based legal practitioner. Thank you so much for joining us.
Thank you.
And we were also joined by Professor Sylvester Odion Ahaene, a political scientist. He joined us from Lagos virtually. Unfortunately, he could not continue when we lost the network contact with him. But all the same, thank you for your time. And for you, the viewers out there, we want to thank you for investing your time with us. And we look forward to being with you again when we bring you a fresh edition of People, Politics, and Power. Bye for now.